afternoon, good evening to everyone, depending in what part of the world you are placed now. It's a pleasure for me, on behalf of the International Association of Youth and Family Judges and Magistrates, to welcome to this space in the World Social Forum. My name is Marta Pascual. I'm a judge in Argentina, and now I'm co-coordinating this event with Andrea Sousa. Andrea is the secretary of the association. Andrea is a prosecutor in Brazil. Our association was founded in 1928 and took part in many important moments of children's rights history at an interesting level. And today we have members in more than 60 countries organizing congresses in each 4 years. The last one was in the House of Paris at UNESCO in 2019. And we expect next one will be Mexico by the end of the year, depending on the pandemic. We are proud to offer to our members and a large community in the world a variety of initiatives aiming to improve the justice system as well as children's rights. We believe that international dialogue has always played a major role in the improvement of the legal system. Now, today, in this space, among a diversity of conceptions of what could and should be a friendly justice, we are part of this World Social Forum to discuss what is at stake with the concept of child-friendly justice, the major concerns, and on a non-discriminatory perspective, addressing some specific and relevant issues in the pandemic. Now, today we have 3 important experts that are going to give their speech. So first, we are going to introduce you to Jean Trépanier. He's a member of the International Association since 1994 and chair the committee which produced the association guidelines on children in contact with the justice system. Jean lives in Canada, and now you have the floor.
Thank you very much. Thank you very much indeed. If we are to debate on issues that rely on child-friendly justice and rights of the child, we might as well define the terms we will be using. And we will see that child-friendly justice and rights of the child are concepts that are intimately linked together. If we look at the guidelines on child-friendly justice of the Council of Europe, child-friendly justice is defined as follows. It refers, and I quote, to justice systems which guarantee the respect and the effective implementation of all children's rights at the highest attainable level, bearing in mind that the principles is listed below, as I'm going to say, and giving due consideration to the child's level of maturity and understanding and the circumstances of the case. It's in particular justice that is accessible, that is age appropriate, that is speedy, diligent, that is adapted to and focused on the needs and rights of the child, respecting the rights of the child, including the rights to due process, to participate in and to understand the proceedings, to respect for private and family life, and to integrity and dignity. Well, that is a fairly long description or definition, of course. Now, we should remain aware that the expression child-friendly justice appears in the English version of the Council of Europe's guidelines. The French and the Spanish versions use a different formulation for the concept. It is, in fact, if we translate it literally in English, the French and Spanish versions talk not about child-friendly justice, but about child-adapted justice. Justice adaptée aux enfants in French, and Justicia adaptada a los niños in the Spanish version. I must say that I prefer the French and the Spanish phrasing of the concept, or another formulation proposed in the guidelines of the International Association of Youth and Family Judges and Magistrates, that is, child-focused justice. In fact, using the expression child-friendly justice appears fully appropriate in matters such as civil, child protection, immigration, and various other fields. It's a different story, though, when we look at criminal matters, where phrasing our objectives in terms of child-friendly justice is unfortunately likely to strengthen the unfair and unfounded stereotype that judges who hear cases of children in conflict with the law are too friendly and soft on crime. In any case, I think we will all agree that children who come into contact with the justice system must see their rights respected and must be treated appropriately, whatever label we use to refer to that goal. Now, treating children as bearers of rights is a relatively new concern. Those of us who have worked for some time in the justice system may remember how things were a few decades ago. If I may refer to my own experience, I joined the Montreal Juvenile Court as a probation officer in 1966. That will tell you a bit about my age. At the time, a typical disposition hearing at the court would have been more or less as follows. The hearing would normally take place in the judge's office, not in a formal hearing room, to keep the atmosphere informal. If the case involved a probation officer who would have prepared a social inquiry report with a recommendation to the judge as to what the disposition of the case should be, the probation officer was invited to enter the judge's office and had what might be called a case discussion on what the court's decision should be. During that crucial time, the child and the parents were not admitted in the judge's office, nor were they allowed to have a copy of the probation officer's report. When the discussion between the judge and the probation officer came to an end, child and parents were allowed then into the judge's office. If needed, the judge asked a few questions and announced what his decision was, a decision, in fact, that had been often made before the child and the parents entered the room. They had been excluded from the decision-making process. Needless to say, the child was not legally represented. The presence of defense lawyers was exceptional, since the vast majority of parents were unable to afford them. And in fact, at the time, there was no state-financed legal aid. This way of doing things was not viewed as illegal. The laws in force at the time vested courts with unfettered discretionary powers. Motives for interventions were often defined in general terms, lacking precision and certainty. Children were not granted rights, were they procedural or substantive. It was felt that granting rights to children would amount to providing them with ways to oppose interventions that they needed and that were in their best interests. This was particularly true for children in need of care and protection and for children in conflict with the law. But such perspectives would gradually be challenged. The 1970s and 1980s were a time of significant changes. If I may summarize very roughly, I mean, following important decisions of the United States Supreme Court, the United States engaged in major changes in their ways of dealing with children in danger and young offenders. In particular, children were acknowledged to have rights. Various countries, as well as the United Nations, followed suit in a trend where acknowledging rights to children was not viewed as a necessary rejection of the welfare model. Such a model could coexist with children's rights. Limits set by the rights of children could indicate how far the influence of the welfare model could go. For example, this can be seen in such United Nations instruments as the Beijing Rules in 1985, the Havana Rules 1990, the Riyadh Guidelines 1990, and most of all, the Convention on the Rights of the Child in 1989. Other important documents have been issued by the United Nations, particularly by the Committee on the Rights of the Child and by other sources. Such instruments and documents have to be understood, they have to be interpreted, they have to be implemented in order to find their ways into policies, legislation, and daily practice. Many of them are written in a legal style that some people with no legal training consider as an obstacle. The various rules that they contain are often scattered in several documents. In brief, their contents benefit from being put together in a single comprehensive document written in a language accessible to a wide group of people and complemented by proper explanations and interpretations. They must be useful to policymakers and legislators, as well as to practitioners whose daily professional activities are devoted to children and justice, such as lawyers, judges, police officers, social workers, psychologists, educators, and others. This is where guidelines can bring their contribution and play a role in the promotion of children's rights. Most existing guidelines on children in the justice system are regional. They were designed so as to be consistent with values and traditions of specific regions, being Europe, Africa, or South America. The International Association of Youth and Family Justice and Magistrates is not a regional association. It draws its memberships from all continents. Its members are mostly judges and magistrates, but they also include other professionals who work in the area of youth and family justice. There's a need for guidelines drawn from a global international perspective to which people may refer whatever country they come from. There's also a need for guidelines that speak as simply and directly as possible to people from various backgrounds who come into contact with the law in the daily activities of the justice system. These guidelines must be phrased in terms that are accessible to all those who are involved in the justice system in whatever capacity and whatever may be their background. They must be based on the experience of actors who, over the years, have developed an intimate understanding of the working of the justice system, of those who make it work, and of the citizens who need its interventions or are targeted by them. It was felt that the association could bring a useful contribution in drafting guidelines that would meet those concerns. Since guidelines are intimately associated with and inspired by children's rights, this venture can be viewed as a contribution to children's rights. Now, if we turn to the contents of guidelines, An overview of the content can give a good understanding of the children's rights we're talking about. First, the scope of the guidelines. Children are likely to come into contact with the justice system for various reasons, including, for example, separation or divorce of parents, custody, protection, adoption, children in conflict with the law, child victims of physical or psychological violence, sexual abuse or other crime, healthcare, social security, unaccompanied children, displaced children, asylum seeking and refugee children, and so forth. So the array of areas in which guidelines can intervene is extremely wide. The children may also appear before various types of courts, be they civil, criminal, or administrative, including in some countries, traditional or religious courts. They may appear as a party or as a witness, and whatever the setting, children's rights must be respected, and the guidelines should apply to all matters where children are in contact with the justice system, whatever they may be. But then, in that area of situation, which right should be concerned with? Let's have a brief look at the contents of the guidelines. This can be quite enlightening. We have divided in the association's guidelines, we have divided the guidelines in parts. The first one being definitions. I'm not stopping on that. The part 2 of the guidelines is about fundamental principles that have in common the fact that they are relevant, that those guidelines are relevant to all situations, and they set orientations for the various elements that are presented in other parts of the guidelines. This part on fundamental principles include, first, the right to be treated according to the rule of law, which must recognize children as subjects of substantive and procedural rights. In fact, there was a time when granting rights to children would have amounted to providing them with ways to oppose interventions that they needed and that were in their best interest. This was particularly true for children in need of care and protection and for children in conflict with the law. Such perspectives were challenged, particularly from the 1960s and 70s. That time is over. Second principle is the right to have the best interests considered as a primary consideration, a key disposition that is central in most decisions. Third principle is the right to participate and to have the children's views heard in proceedings that affect them. In fact, adults must convey the message to children that their contribution to the proceedings is welcome and taken seriously. Questions and other interventions must be in a language easily understood. Cross-examination of child witnesses must be child appropriate and must not be intrusive or hostile. Fourth principle is the right to be respected and treated with dignity. Children must be treated with respect, with care, with sensitivity, and with fairness. Fifth principle, the right to be treated equally without discrimination of any kind. Equal treatment to all, irrespective of race, color, sex, sexual orientation, language, religion, political or other opinion, national, ethnic, or social origin, immigration or refugee status, family condition, socioeconomic condition, disability, birth, or other status. Now, if we move to the next part of the guidelines, it presents general elements of a child-focused justice. These elements are qualified as general in the sense that they are relevant to all stages of the proceedings, being before, during, or after judicial proceedings. They include, first, the right to be provided with relevant information and advice. For example, the right to be informed of charges laid against the child, the possible outcomes and consequences of the proceedings, and so on. Second is the right to a number of procedural guarantees that can ensure the fairness of proceedings. A crucial requirement which applies not only in criminal proceedings, but also in all other types of interventions and proceedings. The third general element is the right to legal assistance and representation, another crucial right essential to have help, to have legal help in all matters, not only in criminal proceedings. The fourth one is the right to hearing where the environment, communications, and the course of proceedings are well adapted to children. We can see here how the right of a child to have well-adapted proceedings is multifaceted. Fifth one is the right to be accompanied by their parents and to remain under their care, which reminds us, amongst other things, the legal obligations of parents toward their children. Sixth is the right to be assisted by an interpreter and other intermediaries if needed, which is obvious as a right. The seventh one is the right not to be deprived of liberty unless required as a measure of last resort and the shortest possible of time. A most important guidelines, that is, that stresses various aspects of the obligation to make only a minimal use of deprivation of liberty. The eighth one is the right to have appropriate age thresholds defined by law for the minimum age of criminal responsibility and for the age up to which a person will be considered a child under criminal law. And I would just mention that the question of those thresholds of the age of criminal responsibility and age of penal majority is a touchy matter for political reasons very often. The ninth one is the abolition of status offenders. Any conduct not considered an offense if committed by an adult should not be considered an offense if committed by a child. It is a matter of equal treatment. The 10th is the right to confidentiality and the protection of the privacy, an issue that attracts public debate, not always for acceptable reasons. The 11th is the utmost importance of avoiding all necessary delays in the proceedings. Delays in proceedings and their consequences do not have all the attention that they deserve, a question that is of the utmost importance. And the 12th and last element on this part is the need for multidisciplinary and interdisciplinary approaches, as well as specialization, selection, and training of both legal and non-legal staff to meet the needs of children. Now, quickly, the following part presents the element of child-focused justice that are relevant to interventions that take place before and during the judicial proceedings. They include such issues as interactions between children and the police, children as victims and witnesses, alternative to judicial proceedings, reminding us that extrajudicial processes and measures have developed considerably over the last few decades, and one should be cautious about the protection of children's rights in that setting. should add also children's access to courts or other bodies, independence and impartiality, of course. And then another element which is very important, the choice of measures imposed on children in conflict with the law. The principles guiding the choice of such measures are at the very core of the differences between young offenders and adult criminals. And then the right to appeal decision, which is an obvious one. And so that provides a good overview of what we can find in those guidelines. Now, I would just end by saying that initially, when the guidelines were designed at the time, the intention was, in fact, to provide inspiration to policymakers, to people who work in the court settings and so forth. But there is one other use of the guidelines that I may mention to you in finishing, and that is the use of guidelines as a tool for training. And we tried to do that at the Paris conference, actually, when we had a good example on how useful the guidelines can be for training purposes. I'm a bit short of time, so I won't go into any details, but I can assure you that the people who did take part in that experiment were convinced that this was a very, very good use, very interesting use that we could make of the guidelines. And we can come back to that if you wish later on. Thank you very much.
Thank you very much, Chan. It was so interesting. You're refreshing us about the principles of the guidelines and also focusing on the necessity of the interdisciplinary, and it has to be an accessible and also easy. I think this is a main problem to be understood by kids and adolescents when they come to our courts, the need of a specialization. And I should say that each judge or magistrate should have the guidance on the desk. Now, our second expert is Tom Liefaard. Professor Tom Liefaard is Vice Dean of the Leiden Law School and holds the UNICEF Chair in Children's Rights at Leiden University, the Netherlands. He's the program director of the Master of Laws, its Advanced Studies in International Children's Rights. Tom teaches and publishes widely on international children's rights, juvenile justice, and child-friendly justice. Tom, thank you for being part of this space, and you have the floor.
Thank you, Marta. Good afternoon, or good morning, or good evening. It's good to be here to join you in this conversation around a very important topic, in English referred to as child-friendly justice, but as Jean Trépanier rightfully pointed out, the term child-friendly justice is not automatically applicable to all the contexts children find themselves in when they are participating in justice proceedings, or where they are forced to participate, or whether they took the initiative themselves. So dependent on the context you are talking about, you may want to use a different term. So I very much like the introduction of Jean. In the very beginning, he mentioned that child-focused is maybe the better term, or otherwise child-adapted. In the context of children as victims and witnesses, we also use the term child-sensitive. Words matter, but apart from that, I will use generally the term child-friendly justice. but not because I'm a big fan of the term. If we look back at the past 30 plus years, roughly since the Convention of the Rights of the Child was adopted and entered into force, we have seen justice reform all over the world. And justice reform with many different outcomes, but nevertheless, a lot has happened since the adoption of the Convention. And I think it's fair to say that the Convention on the Rights of a Child and all the related standards that many of which were mentioned already really created momentum around the protection of children, first of all, the protection of children's rights, but also around the participation of children in decision-making that affects them directly or indirectly, but in essence, is decision-making that is about them. Along the way, in these 30 plus years, we have seen that the concept of child-friendly justice emerged. There was a critical role there for the European Court of Human Rights, which towards the end of the former millennium started to issue decisions in the context of criminal justice that revolved around the accommodation of young offenders, defendants basically, in the criminal justice system. And the European Court ruled that in order to grant children in conflict with the law a fair trial, you should enable them to participate effectively. And in the cases at hand, we were talking about very young children, around the age of 11. So the court, in other words, took the right to effective participation very seriously and brought it within the scope of the right to a fair trial. And in doing so, it really made very clear that for the fairness of the proceedings, children should have the opportunity to participate effectively. So in doing so, it really generated attention around the right to effective participation. And that was later on picked up also by the UN Committee on the Rights of the Child in its first general comment on juvenile justice, which was general comment number 10. It's now replaced by general comment number 24. And for those who do not know what a general comment is a document through which the committee explains how state parties, the 196 countries in the world that have endorsed the convention, should actually implement children's rights in the context of juvenile justice or child justice, as the committee refers to it. And it's interesting to see that in that general comment, the Committee on the Rights of the Child carefully explains that participation and effective participation of children is critical for not only the fairness of the proceedings, but also for its effectiveness. So if you really want to connect to children in conflict with the law, if you really want to make sure that you contribute to their understanding of what was wrong in their actions and how they can learn from it and how they can be reintegrated into society so that they can play this constructive role as international law advocates for, you need to make sure that you connect with children. And one way of doing that is through the participation of children right in front of you as a judge. So the core question of child-friendly justice is, how can you make sure that children participate effectively in the proceedings that are ultimately resulting in decisions that affect them directly or indirectly? And I think in a nutshell, it comes down to 4 critical elements. One is the accessibility of the proceedings. So how can we make sure that proceedings, justice proceedings, are accessible? The accommodation of children. So how can we accommodate young people, children, in the justice proceedings? How can we empower them to engage in a broad sense with justice proceedings, maybe even initiate justice proceedings, but certainly how can we make sure that they know how to engage with the actors within the justice proceedings? And the 4th critical element is that the justice proceedings should be responsive. They should be able to respond to children in a way that children understand the response, but also that they can also, and also in a way that you promote the acceptability of the decision, of the acceptance of the decision, I should say. And this is relevant because it goes straight to the heart of international principles of law, and many of them were already mentioned by the previous speaker. But we also know now much more about the importance of the inclusion of young people and children in decision making through their participation for the outcomes of the decision, and also for the effectiveness, and also for the sense of procedural justice among young people themselves. So we have all the reason to take this very seriously. And therefore, I think it's very important that at the regional level, but also by a professional organization such as the International Association for Youth and Family Judges and Magistrates, that they start to provide guidance to justice systems on how to implement this very important notion with these critical 4 elements of accessibility, accommodation, empowerment, and responsivity. The question I would like to address here today is, how do we make sure that we reach all children? And I think the bottom line of my conversation with you today is that despite the enormous attention around child-friendly justice in the past decade, in the past 2 decades, generated by case law, the attention of the Committee on the Rights of the Child, and these guidelines, I'm not sure whether we have been able to really deal with all children. Are we really capable of making sure that all children benefit from this set of guidelines that are meant to enable all children, each individual child, to participate effectively in justice proceedings? And I think we have to do better there, and I will come back to that in a minute. But if we take a look at the guidelines of the International Association, but let me talk, if I may, a bit more about the European landscape, then I would like to use the guidelines on child-friendly justice issued by the Council of Europe as the example for my talk. There are a number of points that we need to make when we talk about the prevention of exclusion of children from this attention around participation. First, it's very important, as was mentioned before, to note that the child-friendly justice guidelines, and therefore the concept, is about all justice proceedings in which children engage. So it's not only about the criminal justice system, but it's also about the civil justice system, the family law system, the child protection system, the immigration system, mental health system, through which there is judicial decisions, of course. But in addition to that, we also need to think about how to reach out to the more informal justice systems that are in place across the globe to deal with children's issues. And if you zoom in on the text of the guidelines on child-friendly justice, it recognizes that children engage possibly in a wide variety of justice systems, and that this also includes informal justice systems. A study conducted by the African Child Policy Forum, for example, also shows the importance of focusing on informal justice systems. But also informal justice systems could also include, for example, systems that are in place to deal with children outside of the formal court proceedings, for example, through diversion in the context of criminal justice. So also when it comes to diversion, you need to make sure that you reach out to children, that you reach children, and that you enable them to engage with the decisions that are made there. So that's first. The second one is we really have to make sure that we talk about all the groups of children that may be affected by this concept. And the guidelines themselves, they refer to this as the prevention of and the protection against discrimination. And there they list that you need to make sure that you do not differentiate or discriminate between children on the basis of the classical things such as gender and political opinion and nationality or ethnicity. But it's also interesting there that the guidelines refer to the age criteria. And that is basically an incentive to include children, regardless of their age, in this approach towards more effective participation. And that is also the point that the Committee on the Rights of the Child makes again and again and again, that age as such should not be an exclusion, should not be a factor that excludes children from participation. It is instead, it's an incentive to bear in mind that because of a very young age, children may have difficulties in participating. So you should make sure that you have other mechanisms in place so that children, even at a very young age, can participate. And we see that that is happening. For example, children in the context of international child abduction, we see that courts like German courts, but also Dutch courts, but also other courts, they include children in their decision-making as of the age of 6 or as of the age of 4. And that's really a matter of reorganizing yourself around the inclusion of very young children through special guardian ad litem, special assistance, but also special courtroom environment, for example. So age should not be a matter of exclusion. It should actually more be an incentive to make sure that we do everything we can to accommodate. And then in addition, the guidelines flag that there are specific groups that need our attention when it comes to child participation in proceedings and justice systems. And they refer to migrant children, refugee children, asylum-seeking children, unaccompanied children, undocumented children, children with disabilities, also mental disabilities, for example, street children, children in residential institutions. In other words, not only vulnerable children, but also the most stigmatized groups of children in society, and often also the most disadvantaged children in society. The third point of attention, and then I will work towards my conclusion, is that we need to make sure that children can participate effectively, and therefore you also should recognize differences. And I already mentioned age as a factor of concern in that regard. But there are quite a number of children that without anything extra, they will never have any chance to participate effectively. Children with mental disabilities, for example, is a good example, but also children with developmental delays, for example, is a very important group. So in order to make sure that we do not exclude these children, we need to recognize their differences, and we need to make sure that we embrace them and offer additional protection or additional services in order to make sure that they also have a fair chance in being heard and participate effectively. So prevention of exclusion and non-discrimination is not only a matter of equality, it's also a matter of recognizing differences and embracing them. So we cannot implement this concept with all these notions also to promote the prevention of exclusion and discrimination and inequality if we do not really invest in the specialization of our professionals in the system. So that is absolutely critical, that regardless of which professional organization you're talking about, in a criminal justice context, police, public prosecution, probation, judges, but also institutions, for example, they all should be aware of the importance of this concept, but they should also be equipped on how to implement that in practice. And Jean was referring to that as well. So specialization is key. Second, we need to protect children in order to enable them to participate. And that comes with shielding against the negative impact of justice context, It is also a matter of support. It's a matter of language. It's a matter of adaptation. And it's also a matter of not over-focusing on children's vulnerability, but try to reach out to their capacity in order to make sure that they can and have a fair chance of participating. And another very critical element is that we really have to change the way we look at children. If we do not fundamentally review the way we look at children, meaning children as actors in their lives, children as actors in decision-making that is about them, then we will never be able to realize the concept of child-friendly justice or child-focused justice or child-adapted justice to the fullest potential. And that is really a matter of mindset. And I know that that is extremely challenging in practice, but I know that there at the same time are many systems and also many international and national organizations working on this to try to change this. And I think with the guidelines and with all the momentum that has been created around it, there is something happening. Thank you very much.
Thank you very much, Tom, for your interesting and so clear intervention. And this is a very tough problem, the ones that are sitting in courts, that the children are sitting there, but when we talk with them, when they are deprived of liberty, or when they are in some community, they didn't understand anything about the legal procedure and the big gap that is between the legal concept of our intervention and the children, and they need to accept and to be part. I think that they have to be empathic, but they have to be not just to listen, they have to be understood. So thank you very much for your intervention. And now, Andrea, you continue with the coordination and you are going to present our dearest Renate Winter.
Okay, thank you, Marta. I'll take on from now on. And with great pleasure, I introduce Professor and Dr. Renate Winter. She's the Vice Chairperson of the UN Committee on the Rights of the Child, a member of the Appeals Chamber of the Residual Special Court of Sierra Leone. At present, she's the team leader of the European project in Georgia, Europe. Mrs. Renata, you have the floor. Your microphone is off. Okay. Still off. No? Okay.
Now, can you hear me now? Is it possible? Okay, thank you very much. First of all, thank you for inviting me. And I have, just to make a little correction, I am no professor. I am a judge. This is a big difference, and I see that all the time when Jean or Ton are speaking and giving their interventions like super lectures, and when I speak, coming to the very practical things only. So this is the big difference that I have to mention from the very beginning. We have heard almost everything that we could. At the moment, all information about child-friendly justice has been given already by Jean and Ton. Unfortunately, I'm speaking about now child-friendly justice for all children in times of pandemic. And in this regard, once again, I have to question everything, almost everything that had been said because of this exceptional situation we're in. Because when we speak about child-friendly justice, we speak about prevention, about protection, about assistance, and about redress. Of all of those things we speak. And we speak about according to the Convention of the Rights of the Child and the committee, how the committee interprets it, we speak about juvenile or child-friendly justice for all children in all situations at any time. And this is the big difference now for what has been said and what I have to ask you, because my part will be a lot of questions. Article 12, as has been mentioned, is the important article concerning child-friendly justice because it guarantees the right of the child to participate. And everyone knows that if I cannot participate in something, my right is hampered from the very beginning. Now, we have the situation that children are not heard, and I'm now not speaking about Europe or about developed countries, maybe of some, but I am especially speaking from the point of view of the committee for the whole globe. And there we have quite a lot of countries where Article 12, according to our experience, is not at all accepted by nobody in several and quite a lot of countries, more countries than those who accept to deal with Article 12 in a positive way. We have this not acceptance of Article 12 even in so-called normal times. It is by far more difficult if we speak of not normal times, like the pandemic, because we have a huge amount of difficulties. And we do not have them only in the justice system with the people in the justice system, judges, prosecutors, social workers, etc., prison people, etc., etc. We have this problem because the convention and child-friendly justice, as has been underlined by Ton, is not only speaking about criminal justice, it's speaking about civil justice and administration as well. And there we can see that we have really a lot of problems for the so-called not so vulnerable children, as well, and even more so for all the vulnerable children that have been mentioned by Ton and Jean. I go into details if I may. First of all, we say that access to justice is the most important part for all children in all cases at any time. How are we going to guarantee access to justice in cases where access to anything asks for online services? How many children worldwide have online services? The big majority of children in the world has no online services, has not even electricity in quite a lot of countries. So how are we going to deal with Article 12 and listening to them and their problems if they cannot contact at all? And this is a situation that we have worldwide. Also in developed countries like in my own, in Austria, we have seen that the school system and everything connected with the school system is not working for all children in Austria. And Austria is a rich country where we should think that everyone has a computer and access to electricity. It is not the case. And it is even worse in regions like in Africa or in Asia. I'm not speaking about the highly developed countries in Asia. I'm speaking about the other countries. I'm speaking about the countryside in Latin America, etc. There is no service, none. So these children are already excluded in times of pandemic. What about those children who have to deal with courts, but the courts are not working normally? In many countries, courts have, how would I say, emergency system, but not a complete working system because of the pandemic. A lot of judges, a lot of staff is sick or not available. or does not come to service, or has their services online once again. So how to connect these children with the online services of the courts if they have no online service? What about children and the protection of children in the justice system, especially in the penal justice system, if there is no assistance at all? We have social workers, we have probation officers, and we have them almost everywhere. Problem, in pandemia, they are not allowed to visit their clients. They cannot see them. They can reach out to them only online, once again, and there is no online system. What about those children who need transport because they are living in remote areas and there is no transport? I had to deal with countries where during the pandemic there is no transport system working at all. So how to come from A to B if you do not have that possibility to go to a court, to go to any kind of assisting services? What about the protection that we have to have, especially in all states of the justice system, the literal justice system, penal justice or civil justice? I have the possibility to ask for, a child have the possibility to ask for a person of trust if I have a problem in civil or penal matters, even if I have a problem in administrative matters. But there is no person of trust available at the moment because I cannot reach out to anyone. And the system also cannot reach out to anyone except online, if online is available. So you see, the most and the biggest problems in this regard are the technical problems. Furthermore, we have the most difficult issues with the most vulnerable people, as have been mentioned, especially now by Ton and also by Jean. What do I do with a child who wants to demonstrate on the streets against or for corona measures? We have a lot of countries where this happens. Then police comes in. The police is the only one service that really works. So what about the protection in these cases? What about the right to advocate for having a voice, to say something? All is not working. The only one thing working, again, is the policing squad for a time, for this time, for sure. But sometimes maybe some assistance would be helpful. What about the increasing and highly increasing violence within the family? Where is the support for children against their own family? And I'm not speaking now about the increasing of incest and other sexually related violence against children. I am speaking about the so-called normal violence, where father and mother, in the time of pandemic, closed into a small setting, are more and more nervous, and there is nobody to assist the children, and nobody to help them, and nobody to help them to do their homework, if ever necessary, because the parents are too nervous, too exhausted, and become violent. What kind of protection do we have for those children who have online services and who are targeted by pedophiles, by sexting, by bullying, by all this kind of access to negative influences that you have when you are most of the time as a child online. The Committee of the Rights of the Child is just now drafting a new general comment on the protection of children in the IT system. We are not yet ready, but I do think we will have to be very quickly ready so that that can be taken into consideration and implemented to protect those children. What do we do with children in semi-open institutions, also mentioned by Ton? What do we do with them? Do we send them home where they are not welcome? Do we send them home where there is no protection, or do we keep them in the institutions where there is no protection either? What are we going to do? What are we going to do with closed institutions? The committee and many NGOs and many other institutions dealing with the protection of children have asked member states, all member states of the Convention of to the Convention on the Rights of the Child, to really think over possibilities to release children in closed institutions, to release them from pre-trial detention, from everything, and to see if it's not possible to send them home. Again, some of the countries do it, some of the countries don't, because they say, where are we going to send them back? Our pre-trial services do not work. We do not have any kind of probation services who could assist if we release a child on probation. There is nothing, there is nobody working at the moment, or not intensively working, and certainly nobody can visit the children. It's forbidden in most of the countries to visit somebody, like for instance in my own country. What about administration of justice for the migrant and asylum-seeking children? What do we do with them? How do we listen to them or hear them if they are going to be separated by their parents? How are we going to bring them together again? We cannot speak with them. We do not know how to find the parents. We sometimes do know where the parents are, but there is no possibility to connect each with the other, except, again, online, if there are online services. What do we do with street children, please? There is curfew, or there is lockdown. Where should the street children go? There is nowhere to go for them, and only police is dealing with them, just bringing them into closed centers. That's all that is available for them. What do we do with children with disabilities concerning information that is necessary for them? Do we have a possibility to reach out to them? How are we going to reach out to them? Can we visit the families? No, we cannot. Can we visit, services visit them? No, they cannot. It's really, really a problem for even getting information. If there is an emergency because of the pandemic, how are we going to get the children out of their dangerous environment into a secure one? A very practical problem that we cannot yet completely solve. So, and if we now speak about the justice system, the child-friendly justice system goes for alternatives, like Don has mentioned, diversion. How are we going to have diversion systems in place now in a pandemic? How are they going to excuse themselves to the victim? How are they going to deal with the victim if they do not have both online systems? What are we going to set in motion if they want to do community work now in pandemic? Is it the conclusion in this regard would be, okay, this time we do not have diversion. And that is not at all in the best interest of children. What possibilities do we have for information concerning prevention? In quite a lot of countries, prevention information is given by people visiting schools, visiting kindergartens, visiting children where they are to be found. It's not possible during a pandemic at all. And what about redress? What kind of redress can a child give to a victim? What kind of redress can the justice system give to a child victim? There is no way at the moment because, once again, they are not reachable. I'm coming to my conclusion, and my conclusion is bitter. We do not have the possibility that we should have to reach out to all children. Don said we have to reach out to all children. We cannot. In the pandemic, we cannot. And if I think that this pandemic is not the last one that we are going to have, it's about high time that we are setting ourselves in motion, and that we are preparing the system where we can reach out to all children. Thank you.
Thank you, Justice Renate. And you have tagged the issue that one of my questions for you. And so now, if we have time, we have two questions. One from a person that is watching us on YouTube, and she's asking, what would be the challenges related to protecting and guaranteeing the rights of children and adolescents in the Americas? So it's a very precise, let's say, it's a very specific question about the situation in the Americas. It's almost all of them are developing countries, and so on. And I'll just put my question already for the three of you. It's exactly about the internet access, and because the pandemic has proven that maybe this remote working, this home office working, it's something that's coming to stay. And this affected a lot the justice systems, and the hearings of the children, and the hearings of the private, the personnel that work with children, schools, and everything. So I have a question divided in two. Do you believe that the access to internet and to good data and everything is now a social right for children? Because we know that they are experts more than us in these social works and social networking and the computer and cell phones and everything. But not all children have access to these technological things. And I'm talking from Brazil, at least. We have people that have never, children that have not lose one day of school. But we have the other ones that has lost all days of school in a year. So the social gap, the social justice gap is increasing, right? Because they don't have access to internet. So do you think that we can have another social right now, that is access to good internet providers and computers and everything for children also? And also how this will impact the access to justice? Because to those who have access to internet, it's okay. But if for those who doesn't have, if the judges are always online or working from home, and also the social workers and everything. So we have this question about the protection of rights of the children, especially in the Americas, and we can say in developing countries. And also this social work, the social right of access to internet. Thank you. And maybe we can work answer in order. Dr. Jean Trépanier first, and then Tom Liefaard, and then Mrs. Renate Wind.
Yes, actually, on this issue of having the right to internet, to a good internet, as being a social right, well, actually, I don't know if I have much to say about that. I haven't really thought about it in those terms, so I would hesitate to try and provide an answer which might not be very intelligent.
And about the protection of rights in the developing countries, that the pandemic has brought some other challenges. Do you have any?
Well, I'd rather hear what the others can say.
Tom?
Thank you for both questions. I mean, the first one on the developing countries, or maybe, I mean, the question was also in the Americas. I mean, what you see across the globe is the lack of human resources. I think that is a continuous challenge. Of course, there's also often a lack of financial resources, but human resources are also very important. So, for example, when you talk about support for children in the justice system, providing adequate assistance, for example, you're very much dependent on the role of the social workers, for example. And if there's just a few available in your country or in your region, yeah, I mean, how can you actually accommodate that? Eh? So it's extremely difficult. So human resources, I think, is a very critical element here. And in relation to my previous remark, that if you have human resources, then these professionals should be equipped and should also be knowledgeable. And there, I think, particularly in the Americas, we may run into another issue, and that is the perception towards juvenile offenders, for example. I mean, also because of the serious offending that you see in the countries like Guatemala, for example, but also other countries. I'm just now mentioning one, but I could have mentioned others, Brazil maybe. There is also this very harsh response generally also to young people, and the perceptions are very, very critical. And that also may stand in the way of the willingness to accommodate and to address also the protection and participation rights of children. But I think the human resources element is critical here. What we have seen in the pandemic quite quickly, actually, when after they broke out, is actually it confirmed the importance of having caseworkers very close to families. And I know that all the international organizations, including UNICEF, for example, that have tried to, jointly respond to the pandemic, also made that case that the caseworker very close to the family is absolutely critical for many reasons, but also for justice involvement. And then regarding the internet issue and the access to facilities there, well, you can think of a new right, yes, definitely, but you can also say, well, without the means to access internet, you cannot access your right to education. You cannot benefit from access to justice. You cannot benefit from access to healthcare. Already in 2017, UNICEF published a big report on the world and children, and they pointed out there that there is a new dividing line between children that have access to facilities and children that have no access to facilities, internet facilities. And I think if there's one thing that the pandemic shows, that this dividing line has become more problematic, and that is about access to basic services and rights such as education, healthcare, for example, but also, of course, justice. So it's a serious concern. But many rights already acknowledged in the Convention on the Rights of a Child are being threatened by the lack of access to internet facilities. So the right to information and the others that I mentioned.
Yes, I agree. Okay, thank you, Renate.
Yeah, I have now to deal with the other side of the medal, as always, and this is funding. Technical issues cost. Not only human resources cost, but technical resources cost as well. And especially in times of need, in times of pandemic, as a special need, money is not really addressed to children. It was always this way. Children get money when everything else is more or less covered. So we have now to cover housing, we have now to cover medical aid, we have now to cover food, so the basics. And therefore, governments are not really inclined now to do something concerning funding for technical equipment for children. And especially not for those children from whom they think that they will never be voters and will never vote for any of the political parties who are who have to run a country. So many political, how would I say, many politicians are interested in assisting those who might or might not vote for them. Quite a lot of children, especially in developing countries, it is well known that they will never vote. Yeah? Or they will vote only for the one who is going to pay them something. And if it is a bottle of beer. Yeah? So the funding issue is not covered. So we have to find other possibilities than the highly specific technical issues. And for instance, what do you do if a government is giving a huge amount of tablets to all the children around in remote areas where there is no electricity? And in this regard, for instance, we have already found alternatives. Several countries in this country, it was an African country, helped themselves with small solar panels. So that in a community hut, for instance, there are solar panels so that the children can come there with their laptops. So this kind of, how would I say, locally centered possibilities of assisting technically might have a huge priority because they are community handled and not state handled. If there are donors to be found, and very often donors can be found, this kind of problem, if one just has the idea, and if, first of all, you ask the children, because they know how to deal with these issues. Thank you.
So sorry, yes. I have just one last question. I believe that it's more on your area of expertise and work, Renate, but everybody can join in, please. One listener is asking about the situation of children in Greek hotspots in northern Aegean Island, that asylum seeking children, that they have their documents, but they are not accepting as minors. They are treated as adults. And if there is something that can be done for the governments to accept these documents as minors.
Yeah, I do think this has nothing to do with our subject today, but I can try to give an answer. We have written the committee, has written 2 general comments in this regard, the general comments on migration, together with the Committee on Migrants. And there you have especially listed all the problems concerning age determination. If the age has to be determined, there are procedures for that. And the procedures that are usually used, which is X-ray of the hand or X-ray of the teeth, are certainly not correct and not enough, because all those procedures say have a margin of 2 years approximately. Yeah? And if somebody is 18 and says he is 16 or she is 16, then all this methodology doesn't work. But this is exactly the critical age. Or if somebody is 18, says he's 18 and in reality is 20. So we have listed in those general comments, in both of them, the exact dealings with the age. So nobody can say, no government can say that they do not know. Because these general comments are in the open. Every government, every person concerned with age determination can read it. And in several countries, it works already. In several countries, it doesn't. In my country, Austria, the Supreme Court has made a decision along the lines of these general comments. This has to be done, and not only X-rays, in order to accept a person as a child. And on top of it, if nothing works, if really nothing works, then I have to take the principle of the best interest of the children and have to say, in dubio, if I do not know, I have to accept that this person is a child. And I do not know where the real problems are. I cannot there is no refoulement of children, no legal refoulement of children. But if somebody tells me, no, I am not 20, I am not 18, or I am 17, why do I ask for so many different methodologies to find out about the real age? If this person says already, I am 17 or 18, then I have to wait 1 year, maybe half a year, maybe a few months. And then, according to what the child has said, what the person has said, I can deal with the person as an adult. Do I really need to threaten somebody and to use so much money, time, and expertise? If I have to deal with 1 or 2 years, if I take the expertise, and if I take then the possibilities for going from one court to the other, for doing the whole ladder of the justice system back and forward, it takes me for 2 years, no? So I don't think why we could not have a more clever situation and more clever dealing with those issues. This is my answer.
Thank you so much. Anybody can have a comment about that, or somebody else, something else? I want to know if you, Mr. Jean Trépanier and Tom Liefaard, if you have any other final comments. We don't have any other questions, I mean. And Renate, also, if you three, you have the floor, if you have like just some final remarks. Jean?
Thank you very much. That is fine. Thank you.
Tom?
No, I would like to thank you for hosting us and sharing. And maybe the one final thought that I had is we often tend to be very skeptical to individuals who say that they are young people, and sometimes for good reasons. But the committee has again and again advocated, taken the position that you should also give children the benefit of the doubt, so that you. And that is, I think, concurring with the point that Renate just made. And what do we lose if we don't do that? That is really the question. Yeah, that would be my final words.
Yes, yeah. Stop treating children as they were our enemies, right? It's like sometimes it's something like that, right? Renate, your final remarks?
I also want to thank you because I think it is really, really good if people know about the situation in the pandemic concerning children. Most of them don't think so far because they are with their problems, their own daily problems, and don't think about the specific problem of their own children very often. What I would like to say is, first of all, everyone, literally everyone, has to accept Article 12. In good times, because in good times we accept it, it's not that difficult then to accept it also in bad times. But if you do not do that in the good situation, then we have no chance whatsoever in the bad ones. And concerning the aggressive children of Latin America, and not only Latin America, do we not have to ask ourselves first why they are so aggressive, or why they became so aggressive? What are the reasons for that? And if we would have had Article 12 when they were 6 or 8, or maybe 5, would they be there where they are now? And if they are now in prison, is their Article 12 for them relevant? Not at all. So how should they change? Could we think about that as well? Thank you.
We thank you, and in the name of the International Association of Judges and Magistrates of Family and the Youth, we thank you. And if there's something that we can be thankful for this pandemic is this opportunity, because you see, I'm in Brazil, Marta was in Argentina, and Tom is in the Netherlands, and Jean is in Canada, Renate is in Austria. We could never have this kind of meeting if it was not because of this technology and everything. And the opportunity to have 3 experts of your like you, and who freely agreed to join us today. And I also want to say that this session will be on our channel in the YouTube, so it's available for everybody that due to time schedule and timetables could not be join us today. And in the name of the association, again, we thank you so much. We are so grateful. And let's hope that in a few months we are out of this situation. And but we know that our children, we're doing what we can to protect the rights of the children through rough times also, right? And so I just bid you a good day, and thank you so much for this opportunity again. And let's keep safe, because children needs us, and we have to be safe for them also, right? So thank you again, and hope to see you all soon. Bye-bye. Thank you so much. Thank you also to everybody that joined us until now.
Bye.
Bye-bye.